This is Barry Salma speaking for Claim School Incorporated's blog, Salma on Insurance. Today we speak about why a misrepresentation claim against an insured requires production of the actual representations you claim were not true, and why it is not wise for an insurer to attempt rescission without evidence. Desiree Durga and Justin Durga sued Memberselect Insurance Company in the court and responded to the insurer's appeal, claiming that the insurer wrongly attempted to rescind the Durga's insurance policy. The plaintiffs alleged that the defendant breached their automobile insurance contract by rescinding the policy based on an allegation of fraudulent misrepresentation in the application process. The rescission was attempted because plaintiff Justin Durga had 2 or more substance abuse convictions in 7 years. His Michigan operator's license was mandatorily revoked from June 9 of 2007 until requirements have been met. While defendant Memberselect claimed that Desiree Durga's application for insurance contained a material misrepresentation, it did not produce a copy of the June 2012 application. In fact, the defendant admitted the application for insurance no longer exists. The trial court granted the plaintiff's motion for summary disposition on their breach of contract claim and denied the defendant's cross motion for summary disposition, which argued that it was entitled to rescind the policy. The court found that the defendant failed to provide clear and convincing evidence of fraud, and that the plaintiffs had disclosed that Justin Durga did not have a valid driver's license. The court also noted that the defendant's reliance on underwriting guidelines that were not made available to the plaintiffs was not sufficient to support their claim. The court ultimately affirmed the trial court's decision, granting judgment in favor of the plaintiffs in the amount of $82,476.04. Everyone who deals with insurance understands that insurance policies are contracts, and in the absence of an applicable statute, are subject to the same contract construction principles that apply to any other species of contract. An insurance policy must be enforced in accordance with its terms, which are given their commonly used meaning if not defined in the policy. Memberselect asserted the common law defense of fraudulent misrepresentation in plaintiff's application for a procurement of the subject automobile insurance policy that allowed it rescission of the policy from its inception in order to avoid its contractual obligations to pay on the plaintiff's claim. Because a claim to rescind a transaction is equitable in nature, it is not strictly a matter of right, but is granted only in the sound discretion of the court. The insurer, as the party asserting entitlement to the defense of fraudulent misrepresentation, bears the burden of proving the elements of rescission at least, and at best. The question seeking license status of a proposed insured was ambiguous, such that it was construed against the drafter in favor of coverage. As a result, the representation made by the plaintiffs did not constitute a false representation for purposes of establishing that prima facie element of fraud in the application rescission claim. When people seek to procure insurance, by making a clear material misrepresentation to the insurance company, thereby entitling the insurance company to rescind the subject policies of insurance, the insurer must produce admissible evidence of the misrepresentation. Not only had defendant not provided clear and convincing evidence of fraud in this case, defendant insurance company provided no evidence of fraud. Therefore, it was not entitled to rescission. In my opinion, rescission is an equitable remedy that seeks to deal fairly with both parties to the insurance contract. The insurer claimed that the Durgas lied on the application, which they then could not produce because it did not exist. An insurer seeking rescission must do so fairly and in good faith with clear and unambiguous evidence of the misrepresentation. The insurer failed when it was unable to produce the allegedly false application. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you can receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 150 blog postings. Please tell your friends and colleagues about this blog so that they too can subscribe. And if you're interested in receiving further detail about insurance, insurance law, insurance claims, and insurance fraud, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.